Hi, I'm Malcolm Burrows, Principal at Dundas Lawyers. Dundas Lawyers is an award-winning technology, intellectual property and corporate law firm that also passionately litigates in these areas of practice. So in this video, I'd like to discuss the software development agreements, two different broad types of software development agreements, common clauses that you'd expect to find in those documents, and some of the legal pitfalls in software development. So just what is a software development agreement? It's generally a contract where a developer, or multiple developers, agree to build software for their client. There are two broad types of agreements, what we refer to as agile and waterfall methods. In both cases, there is a need for precision in drafting the clauses in these agreements to ensure there's no misunderstanding or misspecification about what has to be developed and how and when. And a software development agreement typically includes details such as the client's requirements, the scope of the development project, and includes a range of substantive clauses to give effect to the meaning of the agreement between the parties. So some of the particular clauses include clauses that detail the development stages, the deliverables, the deadlines for the project, and as experienced developers would understand, there is a significant difference between agile and waterfall in this regard. Waterfall being a fixed set of scope of requirements that doesn't change very much. However, either version of the agreement needs to consider issues such as intellectual property rights to the source code, content as it may be created in a lot of projects, and background IP which might be reserved for a party's exclusive use. And similarly, either type of agreement may include provisions relating to the developer's restraint to protect the client against them creating a competitive product. Common intellectual property clauses include things such as reserving the copyright to the code, in that it might vest with the original author. The problem in software development is that this can mean that the client doesn't actually own the actual code. It's reserved, the ownership is with the client, depending on the scale. So it's very common to consider those issues in software development contracts. The other alternative position is that the copyright in the code can all be assigned to the client. However, that can cause problems for developers who may want to reuse their core code, libraries for example, or they've used those libraries in core systems which they reuse or license, such as some sort of CRM system or CMS, content management system. To avoid these sorts of issues, it's important to particularise each party's intellectual property rights in the contract before the project starts. And one important thing to realise is that copyright must be assigned in writing. A simple verbal contract or a yes, it's going to be yours is not good enough, it must be in writing. We commonly deal with these sorts of problems on a day-to-day basis. So if you're looking for a technology-savvy law firm to advise on software development agreements or in any aspect of a software development dispute, don't hesitate to give me a call on 3221 0013 for an obligation-free and confidential discussion. Thanks for watching.